We turn our attention now to the other high-profile case we've been following closely. Testimony is wrapped up in the trial of Kyle Rittenhouse. The 18-year-old is accused of killing two men and injuring a third during a Black Lives Matter protest in Kenosha, Wisconsin last year. Less than a week after the trial began, attorneys are preparing for closing arguments, which are expected to begin on Monday. Still with me to weigh in on today's developments is former prosecutor Leslie Ricard Chambers and criminal defense attorney Mark Davis. Thanks for staying with us. All right, the big headline is that after just 2 days, the defense has rested its case. Well, that's quick. I want to get both your thoughts on this. Should anything be read into how quickly all of this has gone for both sides? Mark, I'm going to start with you this time.
Well, I think the defense feels like the witnesses that were put on were sufficient enough to establish their self-defense claim. And truth be told, they might be right. One of those witnesses indicated that he, pointed a gun at him before Mr. Rittenhouse, shot him. And that's certainly good enough to make that claim. And I'm not sure about the other witness, the guy who had the skateboard, but the reason that a defense attorney would shut down his case as quickly as he did is because he felt like there was enough information that he can make a strong argument and create some type of reasonable doubt. Typically, a defense attorney wouldn't put on any evidence. And so the fact that they put on some evidence suggests that their case is viable. And so people need to be prepared for what might occur.
Leslie, your thoughts?
I wholeheartedly agree with Mark, even though I'm not even convinced that the defense needed to put on a case because the state's case was so weak just in terms of their strategy and their ability to readily prepare their witnesses. As you all can recall, from the gate, opening statements by the prosecutors were lackluster. They were very straight and narrow pointed, and they specifically held their opinion that they were going to prove certain things, that they were going to prove this, what the elements of the crimes for which Mr. Rittenhouse has been charged with. And then the defense got up and had a more elaborate opening with photographs, with videos, etc. And then you move forward with the state's witnesses who, in some accounts on direct, were able to give some really helpful information to talk about how the victims were not the aggressors. But then we saw the defense time and time again, even with the state's star witness, the surviving witness who was shot by Kyle Rittenhouse, who practically got his bicep shot off, how the cross examination of the defense was so effective in attacking his credibility, even calling him out on his reasons for which, why he's even participating, calling him out on his $10 million lawsuit that he's got against the city, calling him out on the fact that he omitted to mention to law enforcement in the beginning that he also had a weapon. And so, the defense put on I thought, great cross-examination and really defeated the state in a lot of points. And so I'm not necessarily sure that they even needed to put on a case because, Kyle Rittenhouse, he gets up and he's, defending himself. He takes the stand. And I was sort of thinking that while Kyle Rittenhouse was sitting at the defense table, that, maybe he had some things going for himself. He looked innocent. He looked pure. But then he gets up on the stand, as depicted here in this video, and he looks as if he's putting on. He is acting, and he's just doing too much, really. And he's being triggered at points where he shouldn't be triggered. The time for him to be triggered should have been when he was listening and watching those videos and watching himself shoot those people, those victims who survived as well as those who didn't. And so, not sure that he needed to put on a case.
Yeah, definitely interesting moments despite this being short. Let's get to a few things that happened in court today. It was the second day in a row that we saw the lead prosecutor, Thomas Binger, and Judge Bruce Schroeder get into a heated exchange. Let's listen to some of that right now.
I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making? Go ahead, say what you want to say.
I have to say, Your Honor, yesterday I was the target of your ire for disregarding your orders. Today, the defense is disregarding your order. I submitted that draft of that order to the defense. They had an opportunity to review it. They had an opportunity to object to it. We do this all the time in the court system. If I'm being held to obey the court's orders, I'm asking that the defense be held to that too. This is something we litigated at a Daubert hearing. We spent time on this.
You know, I am going to interrupt you, and then I'm going to let you talk again. But I was talking yesterday about the Constitution of the United States and how the Supreme Court has interpreted it for 50 years. That's not what we're talking about here today.
As was the case yesterday, the judge dismissed the jury before talking with Binger. Leslie, what do you think? How much of an impact do you think that that's had on this jury, especially now that they're about to go into deliberations? Even if they didn't actually witness that exchange, they certainly must know that something's up.
Well, I am pretty sure that the courtroom is very tense, especially when the state is either making objections that the court is not granting, especially when the defense is making objections and the court is granting them. And then there have been a few jabs here and there by the judge towards the state. And, you know, the state, and when you're trying a case, prosecutors have to establish trust with the jury, right? Especially when your case is not very strong, and especially when you are getting beat up so bad in your own case in chief. And it doesn't help that you've got a judge that clearly has a history with this particular prosecutor, at least, with some severe disagreements to the point that it becomes somewhat fatal to the state's case. And so those things could play out very, very negligently and fatally for the state, and trying to convince the jury that they have proved their case beyond a reasonable doubt. I don't think that the jury is buying that, and I don't think that the jury is there with the state yet. I don't think that they quite trust him, and they're taking their cues from the judge, believe it or not.
What do you think about that, Mark?
That's very, very true. Certainly the jurors can sense the discomfort between the prosecutor and the judge. Now, at the end of all this, just so the jurors, so that the audience knows, the jurors will receive an instruction from the judge indicating, I hope that you haven't taken anything that I've said or done to suggest that I am favoring one side or the other. But yeah, you can't unring the bell of the interaction that we've had. And they'll use that instruction to claim that there was no misconduct by the judge or by anyone else, because we read this instruction and the jurors are expected to follow every instruction and to disregard anything that may have seemed to favor one side or the other. But at the end of the day, the judge is I think, swaying the jury by being hostile towards the prosecutor. And so it's never a good situation, whether you're on one side or the other. If you have an issue with the judge, that's going to be a problem for your client or the state if you don't have a client.
Well, for such a short trial, there's certainly been some memorable moments. Thank you both for helping us break it all down. Former prosecutor Leslie Ricard Chambers and criminal defense attorney Mark Davis. Glad to see you.